the other day, there have been two cases, more than that, but two main cases since the great debate between Stewart and Lewis about the meaning of the press clause of the First Amendment. The first one was the Florida Star case, which of course ruled in favor of the press in a case that pitted the competing values of protection for individual privacy against the right of the press to publish information of public concern. The other case is the Bartnicki versus Vopper case, which also involved a privacy claim, but it was a privacy claim with a free speech component. The competing values were individual privacy and protecting freedom of speech in a private conversation from intrusion by the press in the interest of publishing information of public concern. The two plaintiffs in the Bartnicki case were teachers union officials in Pennsylvania. And they were contemplating, there was labor unrest with the local school board, and they were contemplating taking dramatic action against the recalcitrant school board. And they spoke on their cell phones, conferred at length, and somebody intercepted and recorded their phone conversation, person unknown, in which one of the officials said that if the school board members didn't budge, we're going to have to go to their homes, blow off their front porches, we're going to have to do some work on some of those guys. Implicit, not too well-veiled threats of violence. Well, the somebody who intercepted and recorded the conversation, dropped it over the transom into somebody else's house and got it to a radio station, which then aired the tape, the recording of the cell phone conversation, and a local newspaper picked it up and printed excerpts from the intercepted and recorded conversation. Well, it happens to be illegal under both Pennsylvania law and federal law, under the wiretapping laws, to intercept and record cell phone conversations and to disclose the contents of any such intercepted or recorded phone conversation. So the two teachers union officials sued the newspaper and the radio station for having violated these laws, which provided for civil remedies, for damages for having violated the laws. And their case went to the Supreme Court, where Justice Stevens, now retired, wrote the majority opinion denying all relief to the teachers union officials and upholding the right of the radio station and newspaper to publish the contents of the illegally intercepted phone conversation. And he recognized that the case presented a conflict between interests of the highest order, the interest in free dissemination of information concerning public issues and the interest in individual privacy, specifically the interest in fostering private speech. The idea is if you know that somebody is recording your cell phone conversation, you're not going to be real candid about what you say, maybe guarded. It has a chilling effect, doesn't it, on what you would say on the phone if it is subject to being recorded, and not only recorded, publicized, put in the newspaper and aired on the radio station. So there's a real conflict of important societal values in this case. Justice Stevens emphasized for the majority that the media defendants, the station and the newspaper, had themselves played no part in the interception. The tape was delivered to them anonymously, and it was a little bit like the New York Times versus the Pentagon Papers case, where the Times received the confidential study of the Vietnam War. It had not itself done anything illegal up to the point of publication. These media defendants in the Bartnicki case had not done anything illegal up to the point of publication, and it was a crime and a tort, subject to civil damages, for them to disclose the contents of the cell phone conversation. The government argued in the case that the statutes were constitutional because they removed any incentive to intercept and record cell phone conversations. But the court found that there wasn't any real evidence, no substantial evidence, nothing empirical, that showed that, in fact, these prohibitions reduced the number of illegal interceptions. I don't know how you would study that. I don't know how the government would come up with that kind of evidence, but the court said, well, you haven't shown us that these prohibitions are effective, that they make a real difference in protecting against illegal interceptions. And in any event, the court said that any privacy concerns give way when balanced against the interest in publishing matters of public importance. I guess you'd have to concede that the threat of violence and the teachers' strike is a matter, at least in that community, of public importance, that the press ought to be able, without threat of punishment, to publish and inform the local community. And then referring to cases like Sullivan that emphasized the freedom of expression upon public questions, the court concluded, as in the Pentagon Papers, that a stranger to this whole transaction between the media and the people who were intercepted, a stranger's illegal conduct does not suffice to remove the First Amendment shield from speech about a matter of public concern. That didn't command a majority in Stevens' opinion, and the result turned on the concurring opinion of Justice Breyer, joined by Justice Sandra Day O'Connor. Their two votes made the majority in favor of the press. And Breyer, as is his wont, emphasized how narrow this decision was. It was limited to the special circumstances that the media had acted lawfully up to the moment of publication, and that what they had published, the content, was a matter of unusual public concern, a threat of physical harm to school board members. So given those twin considerations, the case really turned on that the news media, the press, had not acted illegally up to the point of publication. Admittedly, they knew, they certainly should have known, and they didn't contest that they didn't know, they are taken to have known that it was illegal to disclose the contents of those conversations. but they went ahead and did it. But up to that point, they had done nothing illegal. They hadn't burgled anybody or done the interception themselves. So that's one factor. And the other factor is that the content of what they published was of legitimate public concern. Absent either of those factors, clearly the court would have gone the other way. That is, if it was some silly disclosure of some private information rather than something of legitimate public concern, or if a reporter, somebody acting for the radio station or the newspaper, had actively done the intercepting, then you, I think, can confidently conclude that the court would have denied First Amendment protection. There was a strong dissent. Chief Justice Rehnquist dissented, saying that the majority's decision diminishes rather than enhances the purposes of the First Amendment by chilling the speech of the millions of Americans who rely upon electronic technology to communicate each day. And I have a nosebleed. How do you get a nosebleed in the middle of class anyway? Bear with me. I'll talk to you like this. Anyway, Rehnquist points out that the laws involved here, these wiretapping laws, were not content-based. They were content-neutral. Is that right? They prohibited the interception and disclosure of cell phone conversation. Seems right, doesn't it? Content-neutral. It doesn't say cell phone conversations about anything. Okay.
Was the thing about it being a content matter public report needs a lawyer that was that in the laws?
No, not in the law. No, not in the law. That was a constitutional factor that Justice Stevens used to justify the conclusion that the First Amendment protected the press against punishment in mistakes. Well, anyway, Rehnquist says, look, these laws are content neutral. Well, that's not so bad. That they restrict only information that was illegally obtained by someone. That the laws impose no special burdens on the news media. That is, unlike the statute in the Florida Star case, which singled out instruments of mass communication for punishment if they disclosed the names of rape victims, these laws, the wiretapping laws, don't single out the press. There's no discrimination against the press in these cases. And finally, that these laws promote the privacy and the speech of all cell phone users. Those are important factors, no? Do you agree with the result? Have you become such First Amendment absolutists that you can't entertain the possibility that Rehnquist might be right in this situation, and that these people who were eavesdropped on and then their conversation put out there for the public to criticize, that they have no relief under these laws, content-neutral laws? Well, I think the court came out right. Nicole?
Was this before the Patriot Act?
Yes?
Okay.
What effect would the Patriot Act have?
Well, that's kind of what the government allowing that to be okay. So.
Well, in cases involving potential national security issues, yeah. Are you fearful that that this decision would give undue power to the government to wiretap?
Oh, no, it sounded like they were against wiretapping at first, but then I guess they changed.
Well, Bartnicki's an interesting case. It's still good law. But it remains true that despite Florida Star and Bartnicki, any cases subsequent to the Stewart-Lewis debate, the Supreme Court still has never based a decision on the press clause. That those words or of the press have determined the outcome of any case. Yes, it has repeatedly ruled in favor of the press involving issues that are of vital importance to the press, but as a matter of constitutional doctrine, the court hasn't breathed any actual life into the press clause. So, yes, sir, Alex, no? Yeah.
Do you think there's a main distinction when the court does choose one side or the other?
I can't hear you.
Do you think there's a main distinction when the court chooses, like on the media or on either side of the debate? Is there like usually a one choice or no?
That there's a distinction by the justices
Yeah.
in favor of,
Either the media or
you mean some kind of bias or presumption that the news media must be right, or?
yeah.
No, I don't. In fact, I think several of the justices' instincts, personal instincts, are hostile to the press, to the news media. I mean, look at their hostility to televising their proceedings, televising arguments in the Supreme Court, which would be a wonderful educational tool, showing people how the Supreme Court operates and what serious business it is, and how they grapple with difficult issues in what seems to be an intellectually challenging, demanding way. And people ought to see that. Well, what's the reason why they don't allow it? They don't want to. They don't trust the press, basically. Some of them are fearful that the press will pull out a soundbite from the middle of some argument, and that'll be the news item, which mischaracterizes what was going on. Or it might have been a devil's, what do they call those questions? I'm drawing a blank today. Devil's advocate question, and the press would permit it, would portray it as though this was a genuine inquiry when it was just a devil's advocate type question. So, I don't think they, by and large, I don't think they have any instincts favoring the press or disfavoring the press. And I sure wish they would open up their proceedings. Okay, let's talk about the minority TV case now that it's fresh in your mind, and try to peel back some of the layers of this onion. It turned out, as I said the other day, to be a more challenging assignment than I had anticipated. I tried to find a case that was on its way to the Supreme Court this year, not yet decided, so that you could, based on what you've learned, predict the outcome of the case and predict how the justices would vote on it. And last year, it was the Liar case, and the timing was perfect on that. Well, in this case, there was slim pickings in the Supreme Court this year. There was not the minority TV case, because that's still hung up in the Court of Appeals, but it looks like the Supreme Court potential there, because at least the panel of the Ninth Circuit has held two provisions of federal law unconstitutional under the First Amendment. That's an open invitation to the Supreme Court to pay attention to the case. And then there was another candidate, was the cigarette packaging case that we considered in commercial speech, where the District of Columbia Circuit had held that the requirement that the FDA put on tobacco companies to put gruesome pictures on government-prescribed pictures on their cigarette packages violated the First Amendment. That kind of coerced speech violated the First Amendment. And I was confident that that would go to the Supreme Court because a different circuit had come out differently last year. Instead, the government let it go. They didn't petition for certiorari. They didn't take it up. And then there was one other candidate, which presents a somewhat obscure but clean First Amendment issue. It's the case that's going to be argued next Monday in the court. I noticed when the court granted certiorari in January, and I said to myself, fine, they'll hear it next October and decide it next year. So there won't be anything for the kids to work with. To my surprise, they expedited it, seemingly, and set it for argument next Monday. That's a case that involves a federal law that restricts the nonprofit organizations that are involved in the international effort to contain the HIV epidemic, particularly in Africa. And there are several NGOs, non-governmental organizations, that receive federal money, USAID money, to do something about containing the AIDS epidemic. And the law requires any recipient of this money to have an explicit policy opposing prostitution. Some of the NGOs involved in the effort don't have that policy and don't want to say that that's their policy because they feel that they have to work with prostitutes and the prostitution industry because that's a major source of HIV infection. And they don't want to alienate the people who won't talk to them, won't let them in, and so on, by having a policy opposing the entire business. So they claim that the federal law violates their First Amendment rights by requiring them to state a belief that they don't have. Citing what? The Jehovah's Witnesses cases, yeah, the Pledge of Allegiance case and the license plate case. Government-coerced speech requiring the speaker to adopt the government's position on an issue that they don't believe in. That's the issue before the court. And that wouldn't have been, it's a little obscure, but that wouldn't have been a bad case. If anybody wants to try an extra credit assignment, let me know, and I'll entertain that. What I'd have you do is do the same thing for that case as you just did for Minority TV. That is, write a news article reporting what the Supreme Court decides in that case. That case will be decided before June, but it won't be decided before we finish this course. You know, we only got 2 more weeks of classes after this, after today. Time flies. Anyway, those were the cases that were possible, and I stuck you with the Minority TV case, even though it involves restrictions on broadcasters, a subject that we haven't reached yet. We finally reach it next Tuesday with Red Lion and so on. So it really wasn't, you can claim that it wasn't unfair, and again, I'd like to thank you for not complaining to me about the assignment and for your valiant attempt to work hard on it and peel back the layers of this onion. So let me find out how you came out. I've read many of your papers, but by no means all, and I don't have a complete sense yet of how you came out. How many of you had the court affirm the panel decision of the Ninth Circuit? That is that the prohibition of commercials is constitutionally valid, and the prohibitions on public issue ads and political ads are unconstitutional. So keep your hands up for that one. That's a lot. Why is that? Because there's some sense that mostly the courts don't reverse each other, mostly they affirm? Okay.
Well, I thought it was almost an exception to Citizens United when Kennedy was assigned the majority opinion, and I thought that would be a tough sell to the court, because that was a tough sell that took Scalia questioning the Attorney General to kind of change that opinion. And I was actually fighting that they would strike down all of everything. And I was thinking to myself, like, it's a really hard thing to buy. And how am I going to do that? So then I just decided, maybe I'll just go with affirming, and then I'll have a really good dissenting opinion from Scalia and the rest of them.
So it was you came out that way because it was easier to write, not as a matter of principle.
I was going all the way down the rabbit hole with this thing. It was going to take
Are you happy with the result?
I would have liked to spend more time on it.
No, not with your paper. I'm sure your paper's brilliant, but you don't need any more time on it. But are you happy with the result? If the court came out the way you had it come out, are you pleased? You say that was the right decision.
No, I don't think so, because I think with this particular instance would take it so serious. Like, in the election between Obama and McCain, they said McCain said to go to the X, Obama said to go to the scalpel. I say this should use the scalpel. Like, it needs to be more narrowly tiered. I think more time.
Yeah. Okay. Well, we'll come back to that. Let's find out how